Welcome to the deep dive. Today we are exploring what happens when, the professional rulebook just clashes head-on with the spirit of fairness.
We're looking at a really critical moment in employment law.
Yeah.
It really exposes the vulnerability of people who represent themselves.
The litigants in person,
Yeah.
or lips. And it shows why judges sometimes have to, pretty much rip up the technical rulebook to stop a blatant injustice.
That's right. This is a deep dive into the case of Wendy Wickett v. Sproull Solicitors, LLP. It's a recent tribunal case that should be a huge wake-up call for both lips and professional legal teams.
A wake-up call how?
It's a perfect example of how procedural rules can be, weaponized, and, more importantly, how the judiciary is pushing back to protect people navigating the system on their own.
So our mission today is clear. We're going to analyze the scenario where a 12,000-pound settlement was agreed, then completely lost because of a single administrative email, and then miraculously saved by a, frankly, incensed judge. We want to pull out the crucial lessons about ethics, the rules of settlement, and how you can shield yourself from these kinds of tactical ambushes.
And the stakes here were, they were immediate and they were high. Mrs. Wickett, the LP, and her former employer.
Who were a firm of solicitors themselves, the irony.
Exactly, a firm of solicitors. They'd agreed to settle her claim for £12,000 through ACS. That should have been it. End of story.
But it wasn't.
Not even close. The moment the paperwork started, a simple human error turned into a trap worth thousands of pounds.
Okay, let's unpack this. Section 1, the critical mistake and the trap. It all comes down to the ACS paperwork, right? The COT3 form.
Yes, and it's so important to understand what a COT3 is. It isn't just a simple contract.
It's more serious than that.
Much more. It's a statutory agreement. Once it's finalized and signed, it acts as a permanent legal block. It means you can never raise those same claims again.
Ever. It's a full and final settlement.
Precisely. And because of that finality, procedural steps, they have to be followed to the letter. And this is where Mrs. Wickett misunderstood the sequence.
So she had the draft agreement. The money was agreed. The terms were set. What was her fatal error?
She just believed that since she'd accepted the offer, her only job left was to tell the court that the case was over.
Which sounds logical, to be fair.
It does, but it's wrong. In a moment of, perfectly natural confusion, she emailed the tribunal to formally withdraw her claim.
And the critical mistake was the timing of that email.
The timing. She withdrew the claim before ACS had done their final checks, confirmed everything, and formally declared that written COT3 agreement binding on both sides.
And you can just imagine the solicitors on the other side just watching that court docket like hawks.
Oh, absolutely. They saw that withdrawal email pop up, and they didn't waste a second.
They moved how fast?
Lightning speed. As soon as that notification confirmed the withdrawal, they immediately pulled the £12,000 offer.
Just gone.
Gone. They were banking on pure procedural correctness to save them the money.
But what was their actual legal argument? They'd already agreed to the deal. How would they just pull out?
It was purely technical, but ruthlessly effective. They argued that because she had formally withdrawn the claim, there was no longer an active dispute before the tribunal.
Ah, okay.
And since the whole point of a settlement is to resolve a live dispute, once that dispute vanished, so did their obligation to settle it.
So no dispute, no settlement, no £12,000.
That's it. It was a clean, aggressive exploitation of an administrative slip-up by someone representing themselves.
You really have to feel for her. 1 minute she's 12,000 pounds up, probably breathing a huge sigh of relief. And the next one click costs her everything. That kind of emotional whiplash is, I think, exactly what the judge reacted to.
Precisely. And that brings us to Section 2, the judicial firepower. The solicitors thought they had won. They thought they had sealed it with that withdrawal email.
But they made one big mistake.
A fatal one, underestimating the judge's commitment to actual fairness.
Let's talk about that response, because the language employment Judge Sproull used, it was historic for a legal ruling.
It was absolutely blistering. The judge saw right through the technical maneuver. He saw it for what it was.
Which was?
An attempt by professional lawyers to use a self-represented person's ignorance of procedure to get out of paying a debt they had already agreed to. His official description of their behavior was unconscionable opportunism.
Unconscionable opportunism. I mean, that is not a phrase you find in your average dry legal judgment. That's a moral condemnation.
It is. And it connects directly to the principles of the SRA, the Solicitors Regulation Authority.
Body that polices solicitors.
Exactly. Solicitors are required to act with integrity. And if you, as a professional, know the other person intended to accept the deal, and you use their admin mistake, a mistake you know is a mistake, to save your client money,
then the judiciary sees that as a fundamental breach of integrity. You're using procedure to defeat justice.
and the judge felt he had to call it out, loud and clear.
But the solicitors, they tried to argue their point, right? They basically said, a withdrawal is a withdrawal. A rule is a rule.
They did. They insisted they just reacted legally to a formal action. But Judge Sproull, he wasn't having it. He found the legal footing to override them.
And how did he do that?
He used the power of the tribunal to enforce what's called the overriding objective. His countermove was simple. He just revoked the dismissal of the claim.
So he just brought the case back to life.
Instantly. A procedural resurrection. It completely undid their tactical move.
That's immense power. But explain the thinking there, because this is key for our listeners. How can a judge just override a formal rule like that?
It all came down to the interests of justice. The tribunal's overriding objective, which is in Rule 2 of their procedures, says that cases have to be dealt with fairly and justly.
So it's a conflict between the technical rule and the purpose of the court.
Yes. Judge Sproull basically ruled that when there's a clash between the technical perfection of a rule, a withdrawal is final, and the pursuit of justice, fairness has to win, especially when one party is a vulnerable lippy and the other is a team of professional solicitors.
Okay, but I have to play devil's advocate here for a second.
Or
If Mrs. Wickett had a lawyer, she wouldn't have made that mistake.
Yeah.
Isn't there a risk that by constantly protecting lippies from their own errors, the court actually encourages, well, sloppiness, and undermines the certainty that legal professionals need to close a case?
That's a really valid point, and it's the core tension in the modern system. The judge did acknowledge that rules exist for certainty, but his ruling sort of implies there's a scale of error.
What do you mean?
This wasn't a failure to submit evidence on time. This was a mistake about the order of paperwork during a settlement that was already agreed. The judge drew a line.
So procedural certainty is important, but not when it's being used as a weapon.
Exactly. It stops being the most important factor when a professional party tries to profit from an error they knew was a mistake. They weaponized her confusion. That's what the judge shut down.
So it wasn't the mistake itself. It was the professional exploitation of it. Now, what about the solicitors involved? Was it just a slap on the wrist, or did the judge trigger any formal action?
The judgment itself didn't explicitly order sanctions or training. Its main focus was on getting the case back on track.
But a public ruling with language like unconscionable opportunism? That has to have consequences.
Oh, it creates immediate professional fallout. First, the damage to the reputation in the legal world is huge.
And more formally.
More formally, this kind of rebuke would almost certainly require the firm to self-report their conduct to the SRA. The SRA takes integrity principles very, very seriously.
So even if there's no public disciplinary action, there are internal consequences.
Definitely. An internal review, at the very least.
Yeah.
And what you might call a judicial lecture. It's a severe professional warning shot. They've been told to go back and relearn their ethical duties.
So in a way, the punishment is the judgment itself becoming public.
Absolutely. The case becomes a textbook example of what not to do, which is often more powerful than a fine.
Which brings us to the most important part for our listener. Let's translate this legal drama into tactical defenses. This is Section 3. 3 vital lessons.
These are your shields against sharp practice, taken directly from Mrs. Wickett's mistake and Judge Sproull's correction.
Let's start with Lesson A, the one that nearly cost £12,000. The golden rule of settlement.
This rule is non-negotiable. You have to think of it as your tactical delay button. Never, ever withdraw your tribunal claim until the agreement is confirmed as legally binding.
Let's just drill down on the correct sequence, the only correct sequence.
Okay. First, you agree to the financial terms. Then, ACA draft the legal contract, the COT3.
Right.
Third, both you and the employer agree to the exact wording in that document. Then, ACA has formally declares the agreement binding.
That's the key phrase.
That is the magic word. Then, and only then, after that declaration, is the claim withdrawn. Sometimes ACAS even does it for you. But if you haven't heard the word binding or seen that final signed paperwork, your claim must stay active. It's your only leverage.
Wait for binding. Got it. Okay, Lesson B. Using the overriding objective as your shield.
This is a strategic point. If you, as in Lati, make a genuine admin mistake, and I mean a genuine mistake, not a strategic delay, you have to tell the tribunal immediately.
You admit the error.
Yes, you own it. Don't try to hide it. because that honesty triggers the judge's duty under the overriding objective.
How does that work?
You admit you made a mistake because you're not familiar with the procedure, and you point out that the other side, the professionals, are trying to exploit it. You're basically asking the judge to use their power to make sure the case is dealt with fairly and justly.
So you're asking them to prioritize the substance of the case over the technicality.
Exactly. It puts the burden back on the professionals to defend their aggressive tactic, and often they can't do that without looking opportunistic.
That is empowering. Okay, last one. Lesson C. Using the Wickett case itself as leverage.
Absolutely. You have to remember, solicitors have a duty to the court that comes before their duty to their client.
So if you feel a solicitor is trying to trick you on a technicality.
Right. Not trying to win the case on its merits, but just to block you on a procedural point, you now have a precedent.
So what do you actually say to the judge in that situation?
You cite this case, Wendy Wickett v. Sproull, Solicitors, LLP. You state that the tribunal has the established power to intervene, to look behind the technicality, and enforce fairness when there's evidence of unconscionable opportunism.
So you're handing the judge the justification they need to step in.
You're giving them the tools and the precedent. It turns the other side's sharp practice into a very high-risk gamble for them.
Analyzing this case really hammers home the ethical lines in litigation, doesn't it? It's a powerful reminder that while procedure is, the language of the court, the whole point is justice.
It truly is. And for anyone representing themselves, this case confirms that you are not entirely alone in the system, even when you're up against sophisticated legal teams looking for any tiny crack in your armor.
The system has protections built in.
It has powerful mechanisms to protect against these kinds of ambush tactics. Judge Smale's ruling was a clear judicial warning. Exploiting the procedural innocence of an elippi is not on.
Which leads us to our final thought. We've seen the judge here make a really definitive statement, not just by revoking the dismissal, but by calling out the behavior so explicitly.
So we want you to consider this. How does the judiciary's increasing willingness to intervene in cases of unconscionable opportunism shift the strategic balance of power for a self-representing individual?
And in the end, should fairness always trump procedural perfection? What's the ultimate limit of a judge's intervention when one side is a professional and the other is navigating this complexity all alone?
A question well worth thinking about. We hope this deep dive into the Wickett case gives you confidence and, most importantly, the knowledge of that golden rule of settlement.
Until next time, stay sharp.
And prioritize fairness.